Your Lordship, beg to mention item number 9, Your Lordship, daily listing.
Yes.
Adjournment for the day. The engaged counsel is out of station, Your Lordship.
Let's speak for by learned counsel for the appellate. This matter stands adjourned for 2 weeks.
Obliged.
Lordship, I beg to mention item number 2, Lohit Kumar versus State of Assam. The engaged counsel is not present today due to some health ground. So kindly adjourn the matter for the day.
You are seeking time on behalf of the appellant.
Yes, petitioner.
Let's speak for by learned counsel, same order.
Lordship, if possible, list the matter after 5th of this January.
After 5th December,
5th of January.
it will come 2 weeks we have adjourned. Yes.
Thank you, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 13, Lordship, on behalf of A. Ahmed, Lordship. Lordship, yesterday we have received the paper book, Lordship, from item number 12, Lordship, and officially we have not received yet, Lordship, paper book.
The learned amicus curiae appearing for this case submits that the paper book of the appeal has not yet been formally served upon him, and therefore he is not in a position to conduct the hearing of this appeal today. Full stop. It's connected with.
I have supplied the paper book, my lord. Only I pray for fixing a date, my lord, in January.
Mr. Jiuddin, learned counsel appearing for the appellant in item 12 submits that since both the appeals arise out of common judgment, he has furnished a copy of the paper book to the learned amicus curiae appearing in item 13. Full stop. However, in view of the prayer for adjournment made by the appellant's counsel, a request has been made to post this matter again
10, 17 or 24, my lord.
on 17th of January 2023. Prayer allowed, registry to list these matters again on 17/1/2023 for hearing.
Obliged.
Obliged.
Daily list for orders, item 1.
Your Lordship, Lordship, in this matter, my lord, in this matter, a report was called for, my lord, from the jail authority. A report was called for in respect of Amir Hassan. With respect of Amir Hassan.
Yes,
That report has come, but I think the details are not there. My lord, what happened in this case? My lord, originally medical board by their jail superintendent was sent, in which the BP was very high. So the court directed for a team. The report was sent, but the details were not sent, my lord. No, copy kita ini. Hypertension, PVD, lumbar spondylosis. It was color. PVD is what?
yes. What has happened to the report? It is there on record.
The report is dated 4th of November 22 by the board. PVD মানে peripheral vascular disease.
So the medical report is, have you seen it?
Yes, my lord, with due respect, my lord, originally with this regard, a jail report was sent by the jail superintendent, in which the BP was extreme high. So with that regard, the honorable court directed for the board The board has sent this report without the details of that report, my lord.
Hmm.
The same thing is done, my lord. Only the observation is given. The details are not sent, my lord. My lord, the original on the basis of which this board was constituted, my lord, was on that BP report, in which the BP was extremely high. That was, my lord, I guess it is on record, my lord. Jail superintendent, my lord. It was shown on last occasion before this. দিলীপা, আপুনি এটা report দিছিলে যে, ইয়াতে record আছে নেকি? I do not have that copy, my lord, with me. That is in record, my lord.
So what is to be done here?
My
This
lord,
appeal,
here, the detailed report was asked.
appeal paper book is ready.
My lord.
Yes, paper book is
What
ready.
is the matter for hearing?
Details, in fact, he has said he is otherwise fit, but he has hypertension, DVD, some vascular disease. And he said that it was a number. This is pain in the.
My lord, only with regard to the
So-
hypertension. my lord.
We'll have it on 19th of January 2023.
For hearing.
Final hearing.
Yes,
Yes, my lord, 19 of.
Yes.
Lordship. There are five
My
accused
lord,
persons.
can it be on 24th of January?
All right, 24th of January.
One is on bail, others are inside.
Heard Miss S.G. Borwan and counsel is hearing for the appellant. We have also heard Miss S. Jahan, learned FPP Assam appearing for the state. There is the medical report furnished by the superintendent of district jail, North Lakhimpur, in terms of the order dated 11/11/2022 passed by this court. A perusal of the medical report prima facie goes to show that the appellant Amir Hassan is medically fit, but he has been advised to continue with the medication with a further advice to go for review after 1 month. Full stop. The report is dated 1/11/2022. After perusal of the medical report, we do not find any pressing ground to consider the application filed by the appellant Muhammad Amir Hassan for his release on bail. However, considering the fact that the paper book, the appeal has already been admitted and the paper book is also ready, we deem it appropriate to direct early hearing, expeditious hearing of the appeal. Full stop. As such, come on the request of learned counsel for the appellant, let this appeal be listed for final hearing on 24/1/2023 as a fixed item.
My lord, we do receive report 4/11/2022, not one.
Acha, 4/11.
Mass obligation.
Item 3.
Real nobody is appearing, your lordship. Paper book is ready. One Mr. J. Thomas name is shown.
Why it has been listed today? None has appeared for the appellant. Ms. B. Bhuya, learned APP Assam, is present on behalf of the state oblique respond number 1. Stop. Office note dated 7/12/2022 indicates that service report on respond number 2 is awaited. Post of in view of the above, register to call for service report. Let this matter be listed again after 4 weeks with appropriate.
Item 4.
May I please, your lordship? Lordship, in the service report to respondent number 2 is awaiting. madam.
Your name, please?
PH Kumar, madam.
Sorry,
PH Kumar.
PH?
Kumar.
More. Mr. P.H. Kaur, learned counsel, is appeared for the appellant. Ms. B. Bhuya, learned APP Assam, assisted by Mr. J. Das, is present on behalf of the state, obligation number 1. This appeal has already been admitted. Stop. However, office note dated 5/12/2022 indicates that service report on respondent number 2 is still awaited. In view of the above, office to call for service report on respondent number 2. Let this matter be listed again after 4 weeks with the appropriate office note. Publish note.
And, item 5.
Hello, sir. I have received the paper book, mother. Let me fix it for hearing now.
This matter is ready as regards service.
What is this?
This is the POXO. matter. So what about the victim?
Lordship, informant is the mother and accused person is the father of the victim, your lordship.
Informant is the mother of the victim.
Mother.
So notice has to
has
go. Mr. N.K. Kalita, learned amicus KV, is present on behalf of the appellant. Ms. B. Bhuya, learned APP Assam, assisted by Mr. J. Das, is present on behalf of the state, respondent number 1. The appeal has already been admitted and the paper book is also ready. Full stop. However, although the conviction of the appellant is under section 6 of the POXO Act, it appears that no notice was issued to the informant, who is the mother of the victim. Full stop. Situated thus, we are of the view that notice be issued to the informant respondent number 2, making the same returnable in 4 weeks. In 6 weeks, steps be taken accordingly.
Item 6.
May it please your lordship.
Yes.
My lord, while hearing a bail, though it's nomenclature as criminal appeal, my lord, but it's essentially a bail application, my lord. Then one legal point surfaced, my lord, that whether the person, Mr. Dev, representing some other lawyer actually raised the point, then it cropped in my case also. So now the issue is before your lordship, my lord, that whether by an executive order, which we have annexed it, my lord, they have annexed it, my lord, a PP can be appointed circumventing the mandatory provision of 24 and the consent of the High Court. You have to repeat it.
So appeal is ready for hearing.
First, my lord, actually, we insisted for taking up the hearing in the earlier court, but the court said, by order also, my lord, that first this issue is to be settled. If he has got no locus standi, then how can the appeal be heard?
Which is the order?
Well, it is there, my lord. I don't remember exactly because. Everybody's opinion has only mind and stuff.
No, but then everything can be considered while hearing.
I have got no issue. I'm just pointing it out, my lord. Just pointing it out one letter, my lord, that is their affidavit, my lord, amateur 1, page 113 probably. That is the first issue.
So appeal has been admitted.
Yes, my lord. A hearing took place. Why hearing, my lord?
In fact, started it. Which issue cropped up in another case and subsequently.
Some other lawyer raised it, my lord, regarding his locus standi. Then there were 3 matters, my lord.
Whose locus standi?
Mine.
No, I don't know, my lord. That's why I pointed out.
And
it
in
was
fact, the
not
other cases are over.
But facts remain now, the court want to settle the issue that whether by an executive order issued by the Inspector General of Police, he can circumvent the provision of section 24 and the High Court's consent. Though there is a provision under section 17 of the NIA Act, that NIA can appoint. But whether by circumventing 24 of the CRPC or by an executive order, he can be appointed.
What is the matter here otherwise?
Otherwise, it's a bail, my lord, a lady, my lord, her husband, who is behind the bus for long ago, my lord. Our lady has been catched in this case, my lord, for abatement, my lord. There's some money transaction took into her account. My lord. She's a lady.
Are you ready to argue the matter today, sir? We'll take it up after the other matters. Yeah, this, you will not have paper book here. This is appeal against bill. The case diary is available.
When can you bring it? Case that is not available today. I'll confirm when I can get it.
Well, actually, with all respect to the Friday prayer also, well, so can it be? Today I've got Friday prayer also, unnecessarily stacking up. So can it be taken up in another date, my lord? He'll get the case there in the meantime.
When do you want?
At the earliest, my lord.
On the joint request of Mr. Z. Kamal and his senior counsel appearing to
But actually, he has got produced the case.
Mr. R.K. Dev Chaudhary, learned DSGI, appearing for the respondent. This matter is directed to be
Anything.
listed again on, when do you want it?
My lord, on 15 or 16, what, 16, my lord.
On
That's
16th of,
okay with me.
16th of December 2022 as a fixed item
Yeah.
for hearing. On the next date, please, fix the case diary be
Yes.
produced by the learned DSGI.
Much good.
Item 7.
May it please your lordship. Your lordship, I is there for with a prayer for suspension of sentence and grant of bail, lordship. And the depositions are not readable. So may I place the case from the judgment itself, if your lordship permits?
Yes, please.
Lordship. Your lordship, prosecution case is there. On the alleged date of occurrence, PW1, that is brother of the deceased, along with the deceased in two motorcycles were coming from Sapor to their home, lordship. And in between, lordship, when they reached the place of occurrence, they saw few persons standing, this accused persons were standing near the road. And after going, proceeding forward, lordship, suddenly, Bodiur Jamal and Joinal, they are appellant here, they came out from the bushes and attacked them. And as per allegation of the PW1, Bodiur Jamal first made the assault and thereafter Joinal. And after that, the other accused persons assaulted. This is the prosecution case, lordship. And my case before your lordship is that the PW1 is the only eyewitness and related witness here, lordship. If I go by the deposition of his deposition as well as deposition of the IO, his presence at the place of occurrence makes doubtful, lordship. So, and therefore, lordship, on that count, I will get the benefit of a doubt, lordship, because lordship, he says they were.
All right, Mr. Ahmed, you see, make up your mind on one aspect.
Lordship.
The prosecution has projected someone as an eyewitness.
Lordship.
Now, if the court, after hearing your IA, finds that the eyewitness, his presence is doubtful, then obviously you can expect some favorable order. But in a case where eyewitness is there and it is found that his evidence is trustworthy, normally the courts would not entertain bail applications. So if we hear the matter today in this format, it will be either allowed or rejected. But do you think it will be a better idea to have the paper book and consider the IA? It's up to you. We are just pointing out.
That can be done also.
because the MCR has been received. And it will be necessary because eyewitness was present or not.
No.
This is a very subtle area where the
No.
court has to examine.
No.
So do you think you have the materials to convince the court on that?
Yes, I have, but paper book will be better also, I think.
The paper will be better.
Because they also say that immediate occurrence took place at 8:30. At 10 PM, police came there. Police took the injured person to hospital. He was alive for 8-9 hours. No dying declaration, no affair till then. After 1 day also at evening time, the affair was launched. And he said certain.
That is correct.
Yes.
You see, what happens is, if there is an eyewitness
Okay.
and his presence or her presence is found to be established,
Okay.
and the court finds that the evidence is credit worthy,
Not-
everything else pales to the background.
not that-
Because all these arguments are relevant if it is a case of circumstantial
not-
evidence.
not-
But if there is an eyewitness testimony and it is found to be acceptable,
Yes,
then the links in the chain need not be
Yeah.
established. You agree with that?
yes.
So therefore, here the crucial issue would be that whether
His
there is
presence
actually an eyewitness. We have to,
not-
It's
even
an
to record,
injured eyewitness, your lordship. He also received injury.
even to have a, so it will be practically final hearings,
not-
practically final hearings.
Because that I am kept telling because my understanding is that lordship except Bodiut Jamal and Joinal, although PW1 stated about them, if I exclude these 2 persons, other 4 persons have no implications, lordship. He said that other person assaulted, but doctor found only 4 injuries.
How many injuries? 4.
4,
All lethal, vital part.
yes. And
Where?
but
Head.
6 persons are before your
Injuries are at the head.
head and top head. And it is not
Occipital
probable that assailant will
Let's just see the eyewitness account.
PW1, your lordship.
PW1. So lordship page 19.
Page 19.
19.
Acha, his statement was recorded under 164.
164.
It corroborates. 164 statement corroborates his version.
Yes, to this extent. To this extent.
And why do you say
At page 35, your lordship will find paragraph 20. Page 35, paragraph 20. Immediately, victim was taken by police lordship. Police person SI was there. And as per his evidence, someone else informed him that someone no miscreant's name was disclosed to him. Lordship.
no, which part of the evidence of IO makes his presence doubtful?
Page 21, Lordship.
Page 20.
Page 37, Lordship. Sorry, Lordship. Page 37, paragraph 21.
Yes, which part can you please point out?
First 4 line, your Lordship will find.
Please read it.
Inspector Govinda Deka, another IO, has stated that he was present along with the deceased. Lordship. He took the deceased to the hospital. Your Lordship has seen that on 17/8/2013, he was posted at Salkosa Police Outpost as in charge. On 16/8/2013, this is the date of occurrence. At about 10 p.m., one Abdul Quddus, ex-Jila Parishad councillor, informed him over phone about the incident of murder that took place at Kherdubi. Accordingly, after making general diary entry at Salkosa OP, GD entry number so-and-so, he along with staff went to the Kherdubi. After reaching the place of occurrence, he found one motorcycle, but their case is that two motorcycles were there. And PW1 also a motorcycle was there and he was also taken to hospital, but he found only one motorcycle.
So other motorcycle must have left.
By the time.
What hinges on that? Two motorcycles came there.
Came there.
One was left at the place, the other has gone in.
No,
another-
PW1's case is that from the place of occurrence, his brother and PW1 were taken to hospital by another person in tempo, Lordship, leaving their bike there. It is what it was his case. He found one motorcycle, one so and broken piece. He seized the said items. He know that. So immediately he went there, but no one informed him about the case or disclosed about the assailant. No FIR was lodged immediately. On the next day, the FIR was lodged. And if your Lordship sees the injury of PW1, only injury had abrasion in hand. So he was in a position to disclose those names, Lordship. All right, FIR.
You want an order today?
After paperwork was.
Mr. A. Ahmed, learned counsel for the applicant, submits that although the prosecution has projected the PW1 as an eyewitness, yet if the evidence of other witnesses, including PW13, is examined carefully, then it would raise a serious doubt as to the presence of the PW1 in the place of occurrence. Full stop. Appreciating the above submission of the applicant's counsel would require the court to go through this court to minutely go through the evidence of the prosecution witnesses which are on record. Full stop. However, the paper book in the appeal is not yet ready, although the LCR has also already been received. Ms. B. Bhuya, learned senior counsel in APP Assam, assisted by so-and-so, submits that this IA be taken up after the paper book is made ready. Full stop. In view of the above and on the request of learned counsel for the parties, this matter is directed to be listed again after 4 weeks or immediately after preparation of paper book by the registry for necessary orders. Full stop. Registry to expedite preparation of paper book. You don't have a good case.
If your Lordship sees the entire evidence, then probably I think.
My lord, in this case, from the office note, it appears that ID card has not yet received, nor the service notice is there.
376 matter.
So, my lord, we have taken steps and it is sent from registry on 15/11/22. So may I expect that matter may be listed on 20th December? In the mean, more than 1 month would pass, and if your lordship also desired, then amicus curiae may be also appointed.
You have a application under 389(1).
Yes. I have a good case, otherwise.
What do you have to say? She doesn't agree.
I won't say our case is very strong. Here what had happened, she is a lady and she went to the fish market. She knows the accused. They had tea. She said that he approached me to have tea. I initially was reluctant, but then later I went with him, had tea and then had food. And he
Before the upcoming winter vacations.
Okay.
In this case, earlier NCAP was appointed, but then thereafter I am engaged the party and filed this I application for delivering the result. But the case was registered under section 302. But what is happened, my lord? The occurrence took place at 4:30 of the date of occurrence, my lord, at 4:30 p.m. 30 April, my lord. And the accused died in the 3/5/2000. And on the next day of the occurrence, the FIR was filed before the police station. And police has registered case under section 325 and 506, my lord. And when the case was registered under 325, the first the accused has to be examined. The what injury has been inflicted on him, my lord. And to ascertain the fact whether that injury was sufficient to cause death of a man in ordinary course of nature, my lord. But he was not examined. When died in the hospital after 3 days, postmortem examination is here. And the witnesses stated that he was the accused assaulted disease by a split bamboo. Whether by assaulting a split bamboo is sufficient to cause death, my lord. And moreover, the what type of that is the and the after examination, postmortem examination, but the doctor has found several injuries, my lord. But the witnesses said that only one inflicted injury was inflicted, my lord. That is a discrepancy in the injury. Firstly, your lordship knows that the sufficiency of there must be sufficiency of the injury to cause death of a man in the ordinary course of nature, which is one of the components of section 300 of the IPC. And he must have knowledge, whether he has knowledge of when he has assaulted a split bamboo. And thirdly, whether the injury was, that is the weapon was, that is sufficiency of injuries, and whether he had intention to cause death, my lord. These are the component. Moreover, as per witnesses, the two persons, two boys were chasing the cows in the field when the deceased went to bring his cow from the field. And the two boys were chasing, and at that time, accused has gone there and assaulted the injured, my lord. Who were the two boys? And according to PW1, that two boys has informed PW1 that his brother was assaulted. But that two boys were the most vital witness, my lord, in the case, but they were not examined, my lord. And moreover, according to version of the witnesses, when the two boys were chasing the cows, the accused appeared there and assaulted this with a bamboo. Then what is his motive? Why he would assault the accused? Because the two boys were chasing the cows, and the injured was there, and the accused has gone there and assaulted him. That is the whole thing is mysterious, whether the assault was caused by the accused or by the two boys who were in the field earlier, my lord. The learned trial court relied upon the three witnesses, PW1, PW2, and PW6, my lord. But according to learned trial court, PW1 is eyewitness. But PW1 is not eyewitness. He has himself stated that at the time of occurrence, he was counting battle nuts in his house. At that time, two boys has come and informed him that his brother was assaulted, my lord. So he is definitely not the eyewitness. And PW2 has stated that he saw the injured. That is, he saw the accused assaulting the bed. But at that time, he has not stated that two boys were there. The PW6 has also not stated that two boys were there, my lord. Well, the whole thing is, my lord, suspicious, my lord, whether the assault has been caused by these two boys or by the accused, my lord. If the two boys were assaulted, examined by the prosecution, as it did, the whole thing should have come out. Who has assaulted him, my lord? But these two vital witnesses were. Who are these two boys? They have been examined.
No, lordship, they are not examined, and their recognition is also not clear. Two boys came and said to PW1 that in fact he was chasing me. He being unable to hit us, they hit the deceased on backside of his head with a bamboo. This is what the entire story is. Two boys, I have to check the charge sheet and all. Two boys are not.
Where is the LCR? Give the LCR.
Yes, answer. Their names are also not there, not revealed. PW one said at that time, two boys were in the field. An accused chased the boys to assault, but not succeeding, has assaulted on the backside of the head of my elder brother. As a result,
PW1 is an eyewitness.
no, those two boys had come and told him. He's the brother.
But the two boys have not been identified or examined.
No, immediately I, along with Ujjwal Sarkar, rushed. Ujjwal is PW6 2, perhaps. Ujjwal is 6 2. PW6 is Jacob. Paulush and Tintush. They are not the two boys. Paulush is PW2. Police came and advised us.
So why these two boys were not examined?
Well, what,
They appear to be the eyewitness. As per the-
they will be the eyewitness. The charge sheet, lordship, want to find out. Charge sheet. Addresses of the witness. Or Anthony, Pollard, Tintu, Ujjwal, Jacob, and Milani Bhangra. Boys are not there, lordship. Ranjita Goria and Krishna Topno. The identification of the two boys are not there.
So what is the basis of conviction then?
Because of the statement of PW 1, 2, and 6.
That two
Once-
boys have come and informed them.
And 2 and 6, they accompanied PW 1 after hearing the news to the
Mr.
field.
Sharma, please take your seat. Please take your seat. Please take your seat.
So these are the three evidences, doctor's evidence, head injury.
No, what we are asking you is, what is the incriminating material against the applicant?
And
What is
the,
it?
incriminating materials are PW 1 statement. The boys came and said it was the applicant who had hit the deceased.
But those boys are neither identified nor their
Nor
statement
examined.
recorded. They were not even examined as witnesses. This is a case of.
And the
acquittal.
person died after 3-4 days during investigation.
Then how the charge is proved against the appellant?
The judgment, PW 1 said that.
The
PW
memo, Kapil.
PW 2 had also said. I went to the bring cattle. Raju also came there to take his cattle. Two boys were chasing the cattle, preventing the boys chased them. Professor preventing the boy and with the lathi had assaulted and which
PW 1, 2, and 6 have been relied upon. They have not seen anything. They have not
Yes.
seen anything.
6 did not talk about the two boys. 6 said I had gone there and I had seen Topesar hitting the kid. 6, I'll just read out. 6 said the incident occurred. Deceased Raju Bhengra used to reside in the house. On the day of incident at about 3 p.m. Raju Bhengra went to the field to bring cow. Then accused Topesar inflicted blow to Raju Bhengra with a bamboo piece. At that time, I also went to field to bring my cow and saw the incident. Seeing the incident, I immediately informed Anthony, Ujjwal, and Pintush. Thereafter, along with them, again came back to the field to bring Raju Bhengra. But then the accused chased us with her dog. This is again corroborated by PW8. Accused was standing there after the incident, and mother had given a dog, and the accused were chasing the villagers with that. PW8. PW6 did not talk of the two boys. Only PW1 said.
No, you just read PW 6. He says he has seen the accused hit.
Yes, I saw seeing the incident.
That is his deposition.
Chief.
And what is there in his 161?
161, I had checked. I, in fact, wrote it in my objection as well. Their statements are in same before the trial court and before the police. I'll read out.
Was he broken in the cross? PW 6?
No, it's a small cross. I'll read out. 6. I work in so and so, Tepai state. It is not a fact. It is not a fact that before police, I did not state that on the day of incident, when I went to bring my cow, I witnessed the incident. So there is a kind of contradiction. I'll go to the police's statement. Police is PW 11. He said, PW 6. Jacob Topno did not state before me that seeing the incident, I immediately informed so and so. And thereafter, along with them, again went to the field to bring the injured, but then accused chased us. This he said he did not state.
But did he say that he had seen the occurrence?
He said, because I'll again read out, Raju Bhengra went to field to bring cow. Then accused Topesar inflicted blow to Raju Bhengra with bamboo piece. At that time, I also went to the field to bring my cow and saw the incident. Seeing the incident, I immediately informed Jacob Topno. I'll read out his 161. Jacob Topno, so and so. মোৰ নাম ও ঠিকনা সত্য মোৰ বয়স ইমান মই ছাপৈ টি ষ্টেট কাম কৰো গধূলি 30th of April 2018 তাৰিখে আবেলি 4 মান বজাত চপাই বালিগাঁও ৰাজু ভেংৰাই নিজা মাটিত এখন নিজা মাটিত নেকি ৰাজু ভেংৰাই নিজা মাটিত এখন কি গৰু আনিব যাওঁতে মুন্না ৰাভাৰ লগত তপেশ্বৰ বাঁহৰ লাঠিৰে মাৰপিট কৰি জখম কৰা মই দেখা পাওঁ সিহঁতে কোনো মাৰিব মই পলাই আহো Here also said Topesar আনিব যাওঁতে এটো কি গৰু আনিব যাওঁতে বাটতে ৰাভাৰ লৰা তপেশ্বৰে বাঁহৰ লাঠিৰে মাৰপিট কৰি জখম কৰা মই দেখা পাওঁ In 161 he also said
so he has remained firm.
He remained firm and he did not say about the two boys.
And how the trial court has dealt with the evidence of PW6?
PW6 paragraph 1, 2, and 6 were together. Paragraph, yes. Paragraph 16, last part. PW2, PW6 also corroborates the fact that they are the eyewitness to the occurrence. And they also saw the accused on the spot after commission of the crime. Page number 53. PW2 আকৌ ল'ৰাকেইটাৰ কথা কৈছে।
PW4 is also eyewitness.
Two is eyewitness. 4 is not an eyewitness. He heard from others. PW2 is an eyewitness. Two spoke of the two boys. 2 said, on the day at about 4 p.m., I went to the field to bring cattle. Raju also came there to take his cattle. At that time, 2 boys were chasing the cattle. Hence, accused Topeswar Rao of preventing the boys chased them with a lathi, and with a lathi had assaulted Raju Bhengra over his head. As a result, he sustained injury and he fell down. I, along with Anthony and one son-in-law, brought the injured to the hospital. So he spoke of 2 boys, Topeswar trying to chase them.
Was he shaken up in his?
And then it is not a fact. Before that, I did not state before the police that on that day at around 4 p.m. I went to field. At that time, 2 boys were chasing. It is not a fact. I did not state. I, along with Anthony and son-in-law, brought the injured. It was not shaken. The accused hitting the deceased is not shaken in the cross-examination. Only the contradiction is, I went to the field and 2 boys were chasing the cattle and bringing to the hospital. This part he did not say to the police.
But that is not material contradiction.
That is not material.
If he says something where 2 versions mutually contradictory is flowing from his statement, then of course, but otherwise just mere omission to say something. There are judgments. This court is also. Yes, Mr. Sharma, it appears that this PWs 2 and 6.
It is not a vital contradiction because if the PW 2 and 6 both have seen the occurrence, then why PW6 has not stated about the 2 boys? But PW2 has stated about the 2 boys and PW6.
So then that will require the paper book.
PW6 has not stated about the 2 boys, my lord. The 2 boys, they are the basis of that they have informed the PW1 about the occurrence. On the basis of that information, FIR was lodged. So the PW, that 2 boys with a vital witness and PW 2 and 6 contradicted on the.
That is going to be your final argument.
My lord.
That will be your final argument. Let the paper book be ready, we'll then consider it. At the moment, prima facie, there are 2 eyewitnesses. This is a judgment of May 2022.
Why just PW 2 and 6, my lord. But they have contradicted each other. If both of them have seen the occurrence together.
Mr. Sharma, you are free to argue the matter today. We can pass a final judgment. But you see, these are very, very fine aspects which can be appreciated only once the paper book is ready. What is the contradiction? Is it a material contradiction viewed in the light of the entire fact? Otherwise, prima facie, there are 2 eyewitnesses. They have remained unbroken. They were not broken in the cross. Their main testimony that they've seen the occurrence and
There are
please listen. Their main testimony that they'd seen the occurrence and they had seen the accused appellant hit the deceased on the head with a lathi. That is free from any contradiction. They've stated before the IO, and there is no suggestion even in the cross that that is a false statement.
But regarding injuries also, if the by split bimbo, if the one assault is there, then but the postmortem examination doctor has found many injuries. All injuries are fixed. If a doctor, he has stated that in the cross that all injuries are fixed. And in the also he has given the three.
So if there is one injury, we'll give primacy to the ocular evidence, and maybe it could be a case of a lesser sentence that we'll have to say.
Death sentence, death case, the doctor evidence is paramount considerations, my lord. Because moreover, whether he was case was registered as 325, immediately after the occurrence, injury was not examined, my lord. If he was examined, it would have come out what type of injury has been inflicted on his body, whether that injury is sufficient to cause death of a man in ordinary course of measure. This is the vital thing.
And this will result in conversion. So hearing time, Lordship can say.
That's what we're saying.
conversion
This would at least
Lordship can pass judgment which it thinks that's can over. I am not objecting it.
it could be a case of conversion.
Hmm.
That possibility is there.
Paper book on hold up.
Lesser
Paper
sentence.
book hold up.
That, after paper book, that may be fixed for early hearing of the case.
All right. Heard Mr. K. Sharma, learned counsel appearing for the applicant, also heard Ms. Aslan, learned person appearing for the state. This IA has been filed with a prayer to suspend the jail sentence and also to release the applicant on bail during the pendency of the connected criminal appeal. It appears that the prosecution case is based on the testimony of two eyewitnesses, namely PWs 2 and 6. According to Mr. Sharma, there are material contradictions in their testimony, and the version of these two witnesses does not match the medical evidence. However, from a perusal of the materials on record, we are of the prima facie opinion that both these witnesses have remained firm during their cross-examination as regards their testimony that they had seen the occurrence. Full stop. The other submissions advanced by Mr. Sharma would require minute scrutiny of the materials available on record, which will be possible only after the paper book is made ready. Full stop. In view of the above, registry is directed to expedite the preparation of paper book. This matter will be listed again on 30th of January 2023 for fixing a date of final hearing of the appeal. The IA is kept pending. We are keeping this pending. IA is kept pending.
Yes.
It could be a case of conversion. Take this.
Item 11.
Objection.
My lord, legal aid counsel was.
I'm case for Resolution 2.
Okay.
Yes.
May I start, Your Lordship? My lord, the matter is fixed for consideration of bail, Your Lordship. And my lord, applicant has been convicted, Your Lordship, under section 6 of POCSO Act, my lord. And the conviction is based on, my lord, the statement given by victim.
Regularly cooperating as participating in trial. He was on bail during trial. And but another, on what I'm thinking for Lordship, that the victim in her statement, she has stated that from the alleged place of occurrence, she returned with her elder sister and she explained everything to her. But her elder sister.
How old
is
was the victim?
9 years.
9 years, my lord. His conviction is under section 6. So. Otherwise,
LCR has
statement-
In this yesterday's concluded hearing matter, Lordship, may I please just hand over one decision? I have indicated the paragraphs in the separate sheet.
What is the decision? What is the
This is
point?
Section 59 vis-a-vis electronic record.
Achha, what does it say?
It says evidence that does not contemplate or permit the proof of an electronic record by oral evidence. Requirements under section 65B of the evidence set are not complied with. And in this case also, CD was not produced. Had the CD been produced, then oral evidence would have been taken. The 3 judges decision.
Yes.
Part 2 matters. Item 1, 3, 4 and 5, 7, 10, 11.
Anybody ready with part 2?
16.
Part 2 cases?
Item
4 and 5.
4 and 5.
May please your lordship.
Yes.
Lordship, here two appellants are there, lordship. The case is on the basis of circumstantial evidence. It's a case, although it is not discussed in the judgment, lordship, in the case is on the basis of last seen together theory.
Yes.
Case is that, lordship, on the prosecution case is that on the previous night, one of the accused asked the deceased to come with him around 7-8 PM in PM, lordship. And on the next morning, lordship, his dead body was found in the road, lordship. The case starts from there, lordship. According to them, the last time one of the appellant had taken the deceased along with him, and so the main case starts that they are the accused, lordship. Next morning, lordship, the Ejaha, lordship, one more thing, lordship, in the Ejaha, there are name of two accused person. The one is appellant here, lordship, and the other accused person whose name is there, lordship, he was acquitted by the learned transcript, lordship. And then another appellant is subsequently arrested, lordship.
Yes.
Lordship, the Azahar is lodged by the brother of the deceased, lordship, PW1, page 4. I have the honor to state that around 8 PM on 1/5/2014, accused number 1, Muhammad Azizul Islam, called my younger brother Faizul Islam away on a motorcycle from our house at Amtola, which is under Sodor police station. Accused number 1 took along accused number 2 and making my younger brother sit in between them. They went to the direction of Juria, and thereafter they killed him ruthlessly by stabbing him and slitting his neck with sharp weapon at Tilia Babizia Pathar. Be it mentioned herein that when accused number 1 called my younger brother away, my younger brother's wife Umme Habiba Khatun and my elder brother Muhammad Mustafa Kamal witnessed it. The below named persons witnessed the accused number 1 and 2 taking my younger brother away. I therefore pray to take necessary steps against the two accused persons by looking into the matter and oblige. And witness name they has given Alaluddin and Sahidullah. They are PW 5 and 6, Lordship. PW 5 is declared hostile, Alaluddin, Lordship.
Let us see PW 2 and 4.
2 and 4, Lordship. PW2 is Mustafa Kamal. The informant is my younger brother. I know the accused persons. Some of the accused persons live near my house, while some others live at a distance from my house. Deceased Faizul Islam was my younger brother. It has been about 5 months since the incident took place. The incident took place on the first day of May 2014. On the day of the incident, I was at home. Faizul's wife Umme Habiba and my mother Jahura Khatun were also at home along with me. Around 8 p.m. that night, Azizul came to our house on a motorcycle and was calling Faizul. Thereafter, Faizul went out of the house. When I asked Azizul as to where they were going, he replied that they were going towards Phokotgaon Bazar. Faizul did not return home that night. On the following morning, some people informed me over phone that Faizul Islam was lying dead by the side of Juria Road. Then I went to the house of my brother Mansur and informed him that my younger brother Faizul had been killed. Then as Mansur and I were going to the place of occurrence, police were carrying the dead body on a vehicle. They stopped the vehicle at Amtola and showed us the dead body. I saw Faizul's dead body with a slit on the neck. Cross. I did not witness who killed Faizul and how. My house and that of Faizul are different, but are in the same compound. As shown in the record, the door of Faizul house faces west, while that of my house faces south. If one comes from Faizul house, he reaches my house first and then Mansur house. In my statement before police, I did not mention on what type of motorcycle Azizul had come and what its registration number was, as it was dark. Since I could not read the number of Azizul's motorcycle, I did not mention about it. It is true that in course of my statement before police, I did not state about the fact that on the day of the incident, I had asked Azizul as to where he was going. There had friendship between Azizul and Faizul, and there had no dispute between them. I do not know out of what grudge Azizul and others killed Faizul. The dead body of Faizul was found some 2-3 kilometers away from our house. It is true that I did not state to police that my mother and Faizul's wife were at home on the day of the incident. While giving statement before the police, I did not mention as to where I had seen Azizul and Faizul on a motorcycle. Around 6:37, I could learn over phone from many people that Faizul had been killed. Since I practice cookery, many people know my phone number. They rang me up. On receipt of the phone call, I immediately went to the house of Mansur and informed him of it. The place of occurrence is about 7-8 kilometers away from the place where we came across the police while they was carrying the dead body of Faizul. The name of that place is Amtola. Mansur reached Nagabandha before me. Both of us together come across the police at Amtola. When police showed us the dead body of Faizul by taking it down from the vehicle at Amtola, I did not tell them about the fact as to who had taken him along and who had killed him. When the Ajahar was lodged with the police station, I was not present there. Before lodging the Ajahar, we had a discussion at home and asked many people to that effect. We named the accused person in the Ajahar on suspicion only, since we did not witness the incident. Police took my statement in my house itself one day after the incident. Dokai might have killed Faizul since the latter had rupees 35,000 and a mobile handset with him. And we lodged the case against Azizul and some others out of our suspicion only. PW4 is the wife's lodge.
Yes.
Among the accused person of this case, I know Azizul only. This is Faizul Islam was my husband. The informant is my husband's elder brother. It has been 8 months since the incident took place. On the day of the incident, my husband and I were at home. Around 7 or 8 o'clock on the day of the incident, Azizul came to our courtyard riding a bike. My husband Faizul asked me to give him his driving license, whereupon I gave him the same. He told me that he would purchase a new bike. Then Azizul took my husband Faizul Islam along on the bike he had brought along. As my husband did not return home till 11 p.m., I rang him up but got a busy signal from his mobile phone. At 11:45 p.m., I again rang him up but found his mobile phone switched off. The next morning, my husband's elder brother Mansur Ali informed me that my husband was lying on the ground behind Singai College at Telia Bebezia. After giving me that information, my husband's elder brother Mansur Ali went to the place where the dead body was lying. I was at home itself. My husband's elder brother Mansur Ali told that my husband had been killed by hacking in his neck. After getting the postmortem examination done on the dead body, when police brought it to our house the following day, I saw it. I saw stitch on his neck. I did not notice the rest portion of the dead body. I saw Azizul taking my husband along with him. My husband's elder brother told me that some other person were along with Azizul. My husband's elder brother Mansur lost the case. Police examined me. Cross. When I found the mobile phone of my husband switch off at 11:15 p.m. on the day of the incident, I thought that my husband might have been in his shop and that search of the battery of his mobile phone might have got drained off. Since my husband used to stay at the shop occasionally, I did not worry about him at all. My husband used to stay in his shop occasionally if they had any problem. I have known Azizul since before, as he was the friend of my husband and he used to visit our house on earlier occasions too. My husband had a good rapport with him. I am not aware if my husband had any enmity with him. It is not a fact that I did not state to police that Azizul was at home on the day of the incident. That Faizul, before leaving home along with Azizul, asked me for the driving license, saying that he would purchase a new bike and that after that I had given him the driving license. He went away along with Azizul. It is not a fact that I did not state that at about 11 p.m. on the day of the incident, I had rung him up, but I had got a busy signal from his mobile phone. Then that when I had rang him up at 11:45 p.m., I had found his mobile phone switch off. That the next morning, my husband's elder brother Mansur Ali had informed me that my husband was lying dead with his neck slit behind Singai College. Prior to this incident, Azizul used to visit our house riding a motorcycle, and my husband also used to go out of the house along with him sometimes. I am not aware if my husband used to gamble with others at night. On the day of the incident, my husband had rupees 30,000 to 35,000 with him, and he also took a bank form along to purchase a bike. He did not tell me as to where from he would purchase the bike. Prior to the incident, my husband used to return home at 10:30 p.m. after closing his shop. Besides me, my husband's elder brother was also at home and he also saw Faizul going along with Azizul. I did not tell the police what dress Azizul was clad on. Police did not seize torch or any other material.
So the conviction is on last seen together theory.
Yes, although not discussed as last seen together theory, although alibi was taken, that was negated by the Honorable Court Lodge. It's a trial court lodge. And
so last seen together appears to have been established by PW 2 and 4.
Lordship, that they have stating about an incident, if we believe on their version also, Lordship, on previous at around 7-8 previous night, Lordship, that phone call, etc., those things were also missing, whether they had tracked, etc., Lordship. There are some evidence where one or two witnesses stated that the deceased was with Azizul and one another person. Some said he was with Azizul and Faizul. So far Nazrul is concerned, Lordship, Nazrul's name is nowhere. Still only evidence is 10 and 11 where they are stating about some bike in their house. Only that part for Nazrul, Lordship.
So any evidence against Nazrul?
Lordship, I did not find it, but I have to go through it, Lordship, elaborately. Mostly on Azizul, Lordship. He took the victim on the previous night, madam.
But there, in defense, it is very much clear that they were at that time when the two of the accused stated that they had saw the deceased, Lordship, which is also not corroborating in everywhere. Some contradiction is also there. That they work in a shop, Lordship. They were there. The shop manager and another person working there. They have stated that they were very much there till.
So that is the sum total of evidence. Then it is a homicidal death. That's all.
Lordship.
So he was taken from home in a motorbike.
Money was with him, your Lordship.
Yes,
He took loan on the previous day.
were there. One of them is Azizul.
Yes.
He was made to sit in between.
Yes.
They went out.
Yes.
The next morning, his dead body was found.
Yes.
What is the explanation by the accused that they
Explanation
took the
are
plea of
discussed
alibi?
with- Yes, Lordship. They were in their respective. There is, they had not even tried to escape. Nothing is there, Lordship. They are,
But what happened? Do they say that they have not taken Ajijul? They have
yes,
not
Lordship.
taken
Yes,
Faiz.
Lordship. Yes. 313, they have stated that they were no idea how he died, who had taken
No, no,
them,
but
those things, sir.
did they agree that
Lordship. And
the
one thing,
victim went with them in the motorcycle?
no,
previously?
they have denied that.
That also they
they
had
denied.
denied.
And one more thing, Lordship, so far PWD's wife's person, Lordship, I have even said her 161. 161 also, that was also recorded after more than a month, Lordship. So there is every possibility of.
And what about the motive?
Motive part is not there, Lord. They are very good friendship.
So Ms. Bhuya, you need to go through it very minutely.
Yes.
Will you be able to do it today?
Lordship will do it in the
Monday,
next
Monday
week.
will do?
Monday bench on
Oh, Monday, Wednesday.
All right.
And the
Tuesday.
possibility of dokaiti, etc., were also not ruled out. Even that is also
And the
yeah,
last
from their
injury.
part.
And the judgments, where are the judgments? The probative value, the,
Yes, last
Other
seen together,
conviction.
Lordship. Yes,
it's a weak piece of evidence.
yes, Lordship.
You should minutely go through
My
it
lord, my lord,
because prima facie looks difficult.
my lord.
Then we'll take it up on Tuesday. It will be in the list. It's in the
It's
part.
in part two.
All right, that's all for today. Any other ready matter? Item number 24, it can be taken up on Tuesday. All right.
Hey, Lordship, item number 30, otherwise I'm ready anytime next week.
We want to finish off the judgment.